Let me start our conference. Dear participants, thank you for joining us today. And we start our conference. The topic of this conference is international commercial contracts and the outbreak of the COVID-19. And I'm happy to introduce you, my friend and my teacher, Mr. John Sykes. He is an international charter insurance loss adjuster. He has a very deep experience in sphere of insurance law, and he practiced insurance for 40 years or something like that. And I asked John to give us some presentation about business interruption in the UK insurance market, but I also asked him to describe to us a little bit the insurance market in the UK in general. And my suggestion is John will give his presentation for 15, 20, 25 minutes, as much as he wants, and then we will ask him questions to clarify some of his ideas. And basically, I would like to underline that our conference, it would be better if our conference would be like more question and answer format of questions and answers, because we definitely need to use this possibility to speak with native speakers and ask him to share with us his thoughts and ideas about the insurance market in the UK. We've discussed with John insurance market in the UK many times on different occasions, and this is time when John will share with his knowledge with all of us. Thank you, John, for joining us, and we are all ears.
Okay, thank you, Professor Kanaszewski.
Yeah.
Thank you for inviting me here. I got it right. Thank you for inviting me here this afternoon. I'm going to review a little bit, a very quick bit about myself, and then I'll give you a bit of information of Lloyd's of London, which of course is where insurance all started. Just a couple of little tidbits that you may not know about the beginning of insurance. We're going back nearly, 500 years, so 500 years. But anyway, let me just bring this up first of all, and we will take it from there. And we were just talking beforehand, unfortunately, here in the UK, Prince Philip, who is the husband of our Queen, unfortunately died this morning at the age of 99. But this happens occasionally, and it has resulted. Well, it's a sad time, but he's been ill for a long time, longest serving monarch that we've ever had. So, okay. What I was going to talk about today is primarily business interruption insurance, the UK, and COVID-19. And the reason I brought this up, and the reason Vladimir asked me to talk about this, was because of a major court case at the Supreme Court in London, which came to judgment in January, and it has caused quite a lot of controversy within the insurance market, and it all relates to COVID-19. But first of all, let me give you a little bit of background about myself. As Vladimir said, I've been in insurance for quite a number of years. I started off with the Royal Insurance Group, which is still around, but now known as the Royal Sun Alliance Insurance Group. And I started with them in 1968. I spent 2 years training there. And in 1970, I decided I was going to concentrate on claims. And I was lucky enough to join a firm of loss adjusters called Thomas Howell Self and Company, one of the big boys in the UK at the time. I was with them for 6 years. During that period of time, I dealt with bomb damage claims in Northern Ireland, where there was a lot of trouble going on. And I served in other offices, Stoke-on-Trent, Birmingham, Stafford, I think was the other one. However, in 1976, I was approached by the Graham Miller Group, which was an international firm of loss adjusters, and invited to join them. So I did. And I was posted out to Nigeria, beautiful country. I was there for about 18 months, and then I moved on to Saudi Arabia, and I was in Saudi for a while when I received a call to go to Iran. And I remember the date. It was the 21st of December, 1978, just when the Shah was leaving Iran and Ayatollah Khomeini was coming in. There'd been a major fire up in the Caspian Sea, up in the north of Iran, and it was a power station under construction, and the entire power station had been burnt out. What the insurers were concerned about was the cause of the fire. Was it accidental or was it deliberate as a result of the revolution that was going on? That ended up being one of the biggest claims I've ever dealt with, because it was in the tens of millions of dollars final settlement. Anyway, I stayed in Iran. I couldn't get out because of the revolution. I eventually got out in March, went back to London, was offered to go back to Nigeria or Iran. Well, you'll forgive me, but if you've ever been to Nigeria, you might accept why I went back to Iran for another 18 months. But in August that year, we decided to close Iran because it was impossible to work anymore. And I went to Dubai and opened up an office there for them. And we covered an area from Cairo to Singapore and all of Africa. My speciality was major fire claims, consequential loss claims associated with fire or material damage, marine fraud, and workmen's compensation claims for the American offshore oil industry. In 1984, circumstances were changing, and so I set up my own business and secured a license to trade out of Dubai, which I did for quite a considerable number of years. But by that stage, Dubai was changing. The industry was changing, and I decided I'd had enough. I'd spent many years traveling. I was tired. I was going to retire, and so I did. I came back to the UK, and I have to tell you, after 3 months, I was that bored. I didn't know what to do with myself. And so I decided to, this might amuse some of you, but for some unknown reason, I decided I was going to learn Russian. Please don't ask me why, because I don't remember. But I joined a website, which everybody helped everybody else, and decided I would learn Russian. When they discovered I was British, everybody was asking, could you help me with this? Could you help me with that? I never learned a word of Russian, but what I did do was discover that I could help people with their English. So I took 6 months off and I went and qualified properly to teach English online. And I've been doing it ever since. That's for 10 years, nearly 11 years now. I work primarily with senior business executives and academics and people wanting to go to university to help them either improve their English or pass exams. Okay, so going back to the history of things, let us have a look, first of all, a little bit about Lloyd's, because Lloyd's is, as I said, where insurance all started. The first mention we have of Lloyd's is way back in 1688, and it was in a coffee house, Tower Street, owned by a Mr. Edward Lloyd. And what used to happen there was trading merchants and what was the early stage of insurance. They used to meet there for coffee, discuss about the trading market, discuss how the ships were traveling. And it was mentioned for the first time in the London Gazette, a very famous London newspaper, which is still published to this day. Moving on from there, in 1734, Lloyd's List appeared. Now, if any of you are involved in the marine or insurance industry in any way, Lloyd's List is invaluable because it records and traces the progression of any vessel anywhere in the world. And they get this information from various representatives in the ports. It was that good that the British Admiralty actually used Lloyd's List to find out where their own ships were, because their information wasn't as good as Lloyd's. Having gone on from that, we then had a situation where the first detail of 1750 was when underwriting first appeared. There's no real record of how this started, but it is said that a Quaker businessman in 1757 actually went into Lloyd's coffee house and subscribed to the insurance book, the princely sum of 2 guineas a year. Now, 2 guineas is the equivalent in what we call old money of £2, 2 shillings, which I suppose would be £2, 2 shillings would be 40p. Cost you a lot more. And the only reason we know that was because he had written all that in his journal. So that's the actual first record of underwriting. Trading went on, but in 1764, there was a very important court case. There was a vessel called Mill's Frigate, and there was a claim intimated for the destruction of this vessel. It actually sank. And what was decided was the vessel actually was weak, leaky, and in a distressed condition. And the ultimate decision was, the court decided, that a ship must be seaworthy before leaving shore, and that a policy could not even be paid on a ship which suffered from a latent defect unknown to both parties and the contract. That caused absolute chaos in London at the time, but in due course, that actually formed a major part of English law for marine insurance as we know it today. Now, carrying on during the 60s, insurance underwriters, people investing in Lloyd's, they were making good money, very good money, and they started to take on all sorts of risky cover. For example, they used to take things like highway robbery, death by gin drinking, and things like that. But there was a group within Lloyd's who said, no, we're not doing this. Let's have a bit of professionalism in it. And they pulled away, and they actually went to another place at 5 Pope's Head Alley in London, which was also called Lloyd's. It was another Lloyd's coffee shop. And they created the professionalism and order that we now have in insurance. The other lot eventually died off because they just drank themselves and bet themselves to death. In 1773, we have the first known indication of the principle of lead underwriter. Now, what that means is, with a major insurance policy, one company or one underwriter does not take 100% of the risk. You have what's called a lead underwriter. They set the terms, they set the premium, they set the percentage. And then other underwriters fall in underneath and accept the risk based on the terms set up by the lead underwriter. And a guy called John Julius Angerstein, who incidentally was a friend of Lord Nelson, he set up the idea of the lead underwriter so they could share the risk. And from there on, these sorts of policies were known as Julians after him. And it was the basis for all insurance for the future. One final point, in virtually every marine city, town in the world, you will find a Lloyd's agent. And the Lloyd's agent is there to assist with insurance queries, vessel location, anything else dealing with Lloyd's. And to this day, there is a huge network of Lloyd's agents. Okay, those are just some points following on from Lloyd's insurance. And of course, all insurance is covered from them. Now, we all know about COVID-19, and we all know how this has affected businesses throughout the world, none less than in the UK. We are still under lockdown. In Northern Ireland, we have been under virtual permanent lockdown since October, but for a period of 2 weeks. England, Scotland, Wales are now coming out of lockdown. Unfortunately, we are still in it. How long we're going to be, I have no idea, because our government officials are quite incapable of making decisions, so they can't tell us when they're going to release us. But there's no doubt that the economy worldwide has been badly affected. And the question was, can insurance companies be forced to pay out under business interruption insurance? And as a result of this, there was claims intimated and many claims turned down. But in last year, a court case was taken to the High Court in London, and they made a decision, and it wasn't favorable to the insured. Let me explain, first of all, the two different types of business interruption insurance. The first type is where you have business interruption following material damage. In other words, if you have a factory and the factory is damaged by fire or flood or impact or hurricane or something like that, it follows on that there will be an interruption to that business whilst the premises are rebuilt or equipment reinstalled, etc. And therefore there would be a loss of profit or a consequential loss claim, which follows on. However, there is an exception, there's an extension to that business interruption, which, as a result of a premises being closed and forbidden to trade by the government, there could be a loss of business interruption following this action. Now, the policy was primarily intended for closure from localized diseases or from contamination within a restricted area, normally 5 miles. It was never intended to cover closure as a result of a pandemic such as COVID-19. Nobody thought about that, and the policy wasn't written that way. It wasn't written that way to exclude it, but at the same time, it didn't specifically include it. And this is what all the court cases were about. Was it coverable or not? Now, I'm going to give you, these are just examples of cover. If you want to, we can go into more detail later. But for a material or a claim resulting from material damage, excuse me, business interruption shall mean a loss resulting from the interruption of or interference with the business carried on by you, in other words, the insured, at the premises in consequence of loss of or destruction of or damage insured under particular section to the property used by you at the premises for the purpose of the business. In other words, the factory is destroyed, you have a result in reduction of turnover, you have a loss. That's a material damage business interruption claim. Excuse me just one moment. Business interruption resulting from notifiable disease. Now, a notifiable disease is where you are compelled to notify a local authority. COVID-19 is one of those diseases, although not defined as such. But it means that illness sustained by any person resulting from any human infection or human contagious disease, an outbreak of which the competent local authority has stipulated shall be notified to them, with the specific exclusion of acquired immune deficiency syndrome, AIDS, an AIDS-related condition, or avian influenza. That is the closest they get to naming a type of pandemic, okay? Because there was a huge pandemic resulting from that. So let's now look at what happened. Here is the forefront to the 114-page summary of the judgment. I have copies of this if you want them. It's very boring reading, I can assure you. But what happened was there was an initial claim by the Financial Conduct Agency. Now, that's a regulatory body in the UK that controls everything to do with finance, whether it's insurance, money lending, whatever it may be. The banks are followed under this. And a lot of complaints were lodged with the FCA about the decision of insurance companies turning down claims. So they went to the High Court. And in essence, the High Court favored a judgment for the insurers. The FCA were not happy about this and they wanted to appeal. Now, the next progression is you go High Court, Court of Appeal, Supreme Court. At this time, there was reckoned to be something in the region of 370,000 potential claimants, which is quite a lot. And because of the urgency, the Supreme Court accepted that the case could be brought directly to them without going to the Court of Appeal. So this decision is the final one. There is nowhere else for anybody to go, whether they like the decision or not. They decided to take 8 insurance companies. There were hundreds of insurance companies or underwriters involved. And they used 21 different policy wordings. And the poor old judge had to go through all the 21 different wordings and summarize them and look at them all. But he used those as a basics. And it was agreed that the insurance companies would accept this as a presentation of their case. They had also agreed that this would be a test case, and based on the decision, they would entertain claims accordingly. Okay. As I say, the whole thing runs into 114 pages, which is quite a bit of reading. But the ruling that the judge has made does not mean that policy holders definitely do have business interruption cover, that their claims will be paid. What it does mean, though, that those policy holders that were deemed to have no claims resulting from the High Court decision may now have a claim resulting from this ruling. And that makes a big difference because a lot of companies a lot of insureds either didn't claim or had their claim turned down. Now they can go back and they can start the whole process again. What they did was the judgment's conclusion looked at 6 different points. He looked at the application of a disease clause, the prevention of access and hybrid clauses. In other words, did people have access to uninsured premises? Causation, what was the cause? Trends clauses, this related to how claims were going to be judged. Pre-trigger losses, this related to events that happened before the claim was actually intimated. And then they also looked at a court case in America called the Orient Express case. And this was a hotel in Houston, and in New Orleans, sorry. And I will come to this in a minute because it had a major ruling on the causation. Let's have a look at the first one, the disease clause. This provided cover resulting for an occurrence of a notifiable disease at or within a specified distance of the insured premises. And this is what the judge was looking into. What he found was that each case of COVID-19 is a separate occurrence, and these clauses only cover BI claims resulting from cases of diseases occurring within the specified area. In other words, if there was a case of COVID-19 in Birmingham, which is in the center of the UK, but people were worried and wouldn't go into premises in, let's say, Manchester, which was further up, that wouldn't apply. It had to be close. The distances were different. They could be anything between 5 and 25 miles, but because we had COVID, you could be sure that there was somebody close by that had the COVID. Now, this was a more narrow definition than the High Court, because the court agreed that the policy wordings were not expressed and only applied to instances of illness within the specified distance. And claims could apply in the circumstances of a pandemic. So once a pandemic was declared, didn't matter where you were, okay? You were deemed to be within the specified area. The next clause we looked at was prevention of access and hybrid clauses. These basically are clauses which specify what requirements that must be met before an insurer is liable to pay. Now, for this purpose, the judge used one particular policy and the wording of one of Hiscox's policies. And the court ruled that cover would be provided when a policyholder is unable to use their premises for a discrete or specific business activity as declared in the insurance policy. So if somebody ran a pub and they were forced to close, they couldn't open it up as a record store and claim for business interruption insurance because that business was not the insured business. The result of this meant that under the High Court ruling, people may not have a claim, but now this opened it wide again and has enabled those who were turned down by the High Court to possibly have a valid claim to be considered in the future. Causation. Now, this is a bit complicated, so I hope I can explain it as best as possible for you. The policyholder under a disease clause must show that at least one case of COVID-19 existed in the specified area at the time of the government measure. The government measure was when they issued the order, close, everybody must close, otherwise known as lockdown. There must be a sequence of events as defined in the policy, but the fact that companies suffered losses resulting from COVID prior to intimating a claim, i.e. prior to the government enforcing lockdown, these could not be excluded from the calculation of a claim, whereas under the High Court, they could. Before we had a situation where we had lockdown, people weren't going out. People were scared of COVID-19. They were worried about if they went to shops, if they went to work, they could contract COVID-19. So they weren't going. So as a result, turnover was substantially reduced. Under the High Court ruling, they said that this must be could not be taken into consideration when calculating a claim. The Supreme Court said, yeah, it can be. And this had a major effect on things and will do in the future calculation. Trends clause. In any business, it goes through trends. Last year, things might have depressed in turnover. The previous year, they could have been on an increase. This year, forecasts could have shown, yes, we're going to be on an increase as well. However, as a result of COVID, many companies, the trend was downwards because they just weren't able to trade. They were closed. That was it. Yes, a lot of them adapted quickly and did online trading and were very successful in it. You just need to ask Mr. Jeff Bezos of Amazon. He's done very well out of it indeed. And a lot of other companies have. You cannot make adjustments to cover by the effects of COVID-19. You cannot exclude a regression resulting from COVID-19. And what it means is that whilst prior to the close down, companies were reducing turnover as a result of COVID-19, that has to be considered as a non-trend and cannot be used in the calculation of claims. And again, I will come to that in a little bit. It was known as the pre-trigger loss. The decision was made that for a claimant to calculate a claim, it must be based on the previous year's turnover figures. If turnover had reduced as a direct result of COVID, then this could not be considered as being an overall business reduction in turnover. This was previously excluded, and it now must be taken into account when calculating any loss, okay? Whereas before it would have been ignored. If you want further clarification on that, I will try and give it, okay? The Orient Express case. In New Orleans, there was a major hurricane. As a result, a hotel did not have any business, although the hotel itself was not damaged. And in America, the case was decided that cover did not exist because it would have occurred, the losses would have occurred anyway as a result of damage to the city. The judge here said that was a wrong decision and it should be overruled. And what he has now said is basically, yes, there was a result of business interruption resulting from the fact the whole city was damaged, even though the hotel wasn't damaged, and therefore a claim should be met. This has a major effect on the ruling here, because it goes back to damage resulting from people not coming out. The High Court said, oh no, that's not claimable. The Supreme Court has said, yes, it is, and it must be considered. So what has happened is it has changed the whole thing from the High Court ruling, which basically said, if you resulted from, had a loss resulting from reduction in turnover prior to the government closing everything down, it's not covered. The Supreme Court said, yep, it is covered and it must be taken into consideration when you're assessing what the turnover was the previous year to the closure. And this has caused major concern with the insurance industry. It's great for policyholders because their position now has been strengthened. Those that had had claims previously turned down may have a chance to try again. Those who are still fighting, the ruling is on their side. Remember, with the Supreme Court ruling, it cannot be appealed. That's it. That's the final decision. As a result, insurers now face a possible 370,000 plus claims, and it's estimated this could well amount in excess of 1.5 billion pounds of claims to be paid. They can now review their wordings, and within the definitions made in this decision, they can pay claims accordingly. Now, the FCA made a declaration that they will be working with insurers to ensure that they now move quickly to pay claims that the judgment says should be paid, and where possible, make an interim payment. I can tell you from little bits and pieces I've heard, including, funnily enough, a mention on Twitter last night from a gentleman in Wales saying that his insurance company are turning down his claim. This is still dragging on. Insurance companies are not rushing to pay claims. As they do these days, they seem to use every excuse possible not to claim. And I can see that in due course, there will be another court case, but it'll be against an individual insurance company. And it won't be a test case, it'll be an actual case. Where does insurance go in the future? Well, insurance is nationalized. Will we be able to get business interruption cover of this type in the future? I very much doubt it. I think policies will be reworded with the minimum amount of cover that they will be forced to give. It'll be difficult, but it'll also be carefully worded to include other diseases outside pandemics. How they'll word it, I don't know. Insurance generally is changing. The big insurance company, the first one I worked for, Royal Sun Alliance, has just been bought out by a mammoth American company. So what you're going to end up is with mammoth groups of companies owning the vast majority of insurance. It's going to be heavily controlled. The maximum that we pay claims promptly has disappeared. Insurance companies now fight every claim. It doesn't matter what it is. And they will do their best on that. We now have a situation where we've got various insurance companies, such as one in America called Lemonade. They don't work on the proper basis of insurance. The way they operate is they come with a premium. They take a fee for producing that, and then they put an amount aside for potential claims, and then they say they give the rest to charity. Well, that's fine if you're only dealing with householders, cars, etc. But if you go into the commercial world, it's a different ball game. And how that's going to progress in the future, I don't know. But as a result of this, I can see a major turn in the way insurance will develop in the future, particularly with digitalization that we have. I hope that helps you. I hope it gives you some idea of what's been going on here in the UK. If you want a copy of the court judgment, you can email me direct and I'll be more than happy to send you the PDF of it. Save you searching for it on the internet. Thanks very much for your attention.
Thank you very much, John. It was really interesting, very clear language, and I'm happy to hear you. And of course, I'm envying you because you have so perfect language. I have one question. I have many of them, but one question. You mentioned in the last slide that the regulator, FCA.
Yeah, Financial Conduct Authority.
Okay, FCA as a regulator has some authorities to push insurance companies to pay. Yes. So I'm just interested how it is in practice. For example, I have a claim, business interruption, and the insurance company is supposed to pay, but it doesn't pay. What should be the course of action? What is the course of action for me? Should I go to the court, which is kind of expensive, or I may to apply to FCA and ask them to push the company to pay me a compensation? What do you think?
You can ask the FCA to look into the case. They won't necessarily, and this can be anything to do with banking, investments, anything like that. You can contact the FCA. they will not necessarily push the insurance company, but they will find out the insurance company's reasons for turning down your claim. And then you can decide from there whether you want to go as an individual and take the insurance company to court. The reason the FCA got involved here directly was because of the vast amount of claimants. It couldn't be done individually. It had to be done on a select basis, select number of insurance companies, select number of policy wordings, and the FCA representing all claimants. That was the only way it could be done. It couldn't have been done by individual claims.
Okay, and the next question is, when you described this case, this High Court case, you mentioned that the judge referred to the U.S. case. I don't remember the name of the state.
Yeah, the Orient Express Hotel.
Yeah, the question is it possible for the UK judges to refer to the foreign case law, as in this case?
Yes, because this was one of the cases that had been pushed through as by the insurance companies, and they had used this as a basis, or some of them had used it as a basis for turning down claims. So whilst he can't actually change the law in America, he can look at it and say, I don't agree with this, therefore you can't apply it. He can't change the decision of the court, but he can, same as you can in your country, you can say, okay, there's been something happening in the UK. We don't agree with that decision. This is our decision. And that's what he did. Okay,
thank you. And any other questions from the participants?
Can I ask a question?
Yes, go ahead.
Good afternoon, Mr. Sykes. Thank you very much for this interesting report. I have actually two questions. The first one, when you were talking about the turnover analysis, how far do they go in analyzing the turnover?
1 year.
1 year, 1 year.
The previous year.
But there might be some companies that were very bad in the beginning. Then there was this 1 year, which was very successful, but then they go into the COVID, so still 1 year.
Tough is basically what I can say. There had to be some line drawn, and so it was decided on 1 year.
And the second question will be, did this affect in any way the contract practice in the insurance companies? I mean, do they change their clauses? Do they make it more specific in order not to allow them to go into the COVID pandemic?
They will probably do that, yes. In fact, I have no doubt that they will, because, as I said at the early stages, the business interruption disease section was not intended for pandemics. It just wasn't there. And so they've been caught out. So yes, I have no doubt that they will rewrite the wording. It'll never be a standard wording. Different companies will rewrite different things. But no, they won't want to go through this again. And whether we like it or not, and I'm not a forecaster, there are going to be other pandemics. No question about it.
Yeah. Thank you very much.
You're welcome.
Any other questions? So no questions from the people. I have a question. My question is concerning the term underwriting. Underwriter. Mm-hmm. What does it mean? Underwriter is someone who is underwrites in the insurance policy. Yes?
Underwrites the risk.
Underwrites the risk.
Mm-hmm. Yeah, that's what
And who are them? Are they individuals or are they companies, or do they need a license? Do they have to be licensed? Or for example, can I, as a citizen of the Russian Federation without any background in the UK law, can I be or may I be underwriter?
You wouldn't be an underwriter. And now we're talking Lloyd's here only because insurance companies are completely different. In Lloyd's, you have what are called names. And if you've got enough money, you can be a name. You then join an underwriting syndicate. which is a group of names. That syndicate then appoint an underwriting agent, a managing agent, sorry, and it is the managing agent that does the actual underwriting itself. Anybody can be a name. Yes, there are certain terms and conditions. It was changed a number of years back where you could be personally held liable to the full extent of your assets and everything. That has been limited slightly, but you still need a fair bit of money to be a name. And a lot of wealthy people of all different types from all around the world are names. In fact, I remember back in my earlier days that you weren't considered rich unless you were a name at Lloyd's.
And the question, I have also a question related to your specialty. What does it mean? Loss adjuster. What was your job? You know, what
Well, in
action
reality, I
you were
mean, we
supposed
adjusted the losses. Our function was always to be an independent investigator and negotiator of settlement of a claim. A loss adjuster is appointed by an insurance company. Yes, the insurance company pay the fee, but our job is to be there and find out what the cause of the claim was. Was that covered under the policy? And then negotiate settlement within the terms and conditions of the policy. For example, we're looking for proximate cause. In other words, what caused the fire? Was it a little electrical short circuit, which then caused a bigger fire, which caused something else? Proximate cause is that initial incident that sets in motion a train of events that brings about the result, the destruction of the building. If you have, for example, a 3-year-old car and it's damaged completely in a crash and you claim under your insurance company, the insurance company will not give you the price of a new car. They will give you the value of a 3-year-old car. It's the same with indemnity under a material insurance claim. There will be equipment in a factory that's not new. There will be computer systems that aren't new. The insurer's job is, well, our job was to estimate what was the actual value of that equipment at the time of the loss. And this, of course, is where a lot of arguments will come into play as to what the actual value was. And once that was accepted and we agreed settlement, then that claim would be reported to the insurance company and they would then pay according to our report. They didn't argue with us. What we said went. When it came to consequential loss, that's a different ball game. I mean, you're into a whole lot of figures. As you asked me, what about previous years? Yeah, we would have had to go back into all of that, look at trends, etc. What were standing charges? What were regular payments? All of this that came into consequential loss claims. And not everybody dealt with consequential loss claims. Just for the record, my father actually was also in insurance and his entire life with the Royal Insurance Company. When he retired, he was reckoned to be one of the top loss of profits insurance people in Europe because there weren't many specialists, and that's what he had, an accountant's mind, and that's what he specialized in. There are very few experts in that field these days.
And the question, which is also in my particular interest, what does it mean, consequential loss? I remember we discussed this issue with you, I don't know, a couple of years ago.
It's a financial loss resulting as from a consequence of another damage.
Could you please elaborate a little bit? I mean, maybe you can give us some example. For example,
well, you have as a result of a fire. As a result of COVID-19, there is a consequential loss coming from the initial cause, which is COVID-19. So it's a as a result of one incident happening, another occurs. Okay, and that's the consequential loss.
So basically,
It's referred to as a number of things. It can be referred to as consequential loss, loss of profits, business interruption. It has various terminologies.
Okay. So okay. Do you have other participants? Do you have any questions? I have one more question because my colleagues keep silence. They're a little bit shy, you know. They have more advanced language that I have, but I'm not a shy person, you know.
Forgive me, but you're all law professors. I've never met a shy law person.
Me, I was a shy person before I met you. Perhaps you've told us that this case, which was considered by High Court, will have enormous influence on the UK.
Supreme Court.
Or Supreme Court will have.
High Court, Court of Appeals, Supreme Court.
Yes, will have influence on your insurance market and internal business market as a whole. My question is, what happens if, for example, insurance company will just not pay?
The decision is already made. If they refuse to pay, then the person can take them to court and cite this court the decision.
Okay, yep. But many companies, because of the COVID-19, many companies went to bankrupt. Now they don't have money to go to the court to pay for this all costs, you know, and fees.
I haven't heard of any companies going bankrupt here.
What?
I haven't heard of any UK companies going bankrupt yet.
So you don't have? So they didn't?
Not yet.
Not yet. Even one?
No.
And what about personal businesses?
Pardon?
The small businesses, the ones that the restaurants,
the small businesses, but the insurance companies haven't gone.
No, I was not talking about insurance companies. I'm talking about the clients of the
there's many of them gone bust. Yes.
Okay.
And there will be many more.
Many of them went to bankrupt, and now they do not have any money to pay for the cost fees. Maybe it is a good strategy for the insurance company just do not pay to them because you know they will never appear in the court. They don't have money, you know.
Well, we have a legal aid system, and whether that can be brought in, I don't know enough about it to decide. But I think that with this Supreme Court ruling, that an insurance company would need to be very, very sure of its grounds before turning down a claim. Would need to be very sure, because it's in direct contravention of what the decision has been given.
Mm-hmm. Okay. Any other questions from the audience? Alexander Kovalyov.
Go ahead.
Okay.
We were talking about these different clauses. I mean, the 6 of them. Do they usually apply all 6 of them in the contracts? Do they stipulate 1, 2, or maybe all of them are included into the contract?
Normally all of them, but it's the interpretation. They're not specified as contracts. It's how they're incorporated in the policy. So
if I have several clauses, like the one with the turnover clause, the other one with the pandemic clause and all this stuff, so I may consider myself protected over all the losses. Mm-hmm. And if I forget about one, so this means that I'm protected only from another one clauses. It
would all be within the policy. It's unlikely. The purpose of this court case was to give a clearer definition as to what was involved. For example, we talked about, I haven't got the sheets in front of me, just 1 second. I've forgotten which clause it was. How come computers never work when you want them to? We were looking at the causation. In other words, what was the cause of the damage? That was defining it more. So the trends clause, the pre-trigger loss. Okay, not so much a clause, but a definition as to what could be considered as a coverable item. Which, if you had a loss of turnover resulting from lack of visitors to your premises as a result of COVID, that is covered, or that should be taken into consideration when determining the trend. So it was more clarification.
I think it's a bit hard to prove sometimes. If we have this pandemic, everybody will say that well, we have this problem with the overall custom visitations, but we do know that sometimes it could have happened just right before the pandemic, but people could have stopped coming there, and then this pandemic, and they say, oh, pandemic, now we have protection, and they can use it.
No, because I mean, your natural trend, you would have a look at your figures. I mean, remember, we're looking at a year's previous figures, so we would have had turnover before then, and we can look at previous years before that. To calculate the loss, we're looking at the 1 year, but we can look at previous trends to see how that has affected the business.
So you can still use the previous years in order to show that, well, sometimes this is not the correct numbers?
Correct. Yeah. You got to remember, an insured has got to substantiate his claim. It's his job to prove his claim. You know, it's not for the insurance company to say, oh, well, look, if you give us 6 years figures, we'll prove to you that. That's not the way it works, I'm afraid. You know, in the early days, I remember, I mean, just when I first started in insurance, if you had, say, a simple household storm claim and your chimney was blown down or there was roof damage, you could turn around to the insurance company and say, oh, I had a storm. When was it? It was sometime in the last month or so. Okay, no problem. We'll pay the claim. Now, day, time, etc., and they'll whip up the weather details for your house at that particular time and say, nope, there wasn't a storm. It was the following day or something like that. It's up to you to prove your loss.
Mr. John, if I, for example, insure a person and I want to get a compensation from the insurance company, and how I can prove that the number of so basically I can use, from my perspective, I can rely only on the accounting documentation from the previous years. This is the only evidence or proof I can bring to the court, because, for example, if it comes to the court proceedings, shall I ask to visitors to come and be my witnesses in the court? Of course not. Probably I will ask to bring, to give me some accounting documents. For example, my income for the previous years was, let's say, £10,000. So this is my loss in this year because I don't make this money anymore. This will be the course of action, or I still need to bring some witnesses who will tell that, okay, we were in this restaurant last year.
Those days are gone. You have to give actual concrete evidence, particularly on accounting. The difference between accountants and loss adjusters when it comes to accounting a loss, accountants look at it from an accountant's point of view. We look at it from an insurance point of view, and there is a difference. There's an old saying, there are lies, damned lies, and statistics.
Yes, we know it. Yeah, we know it. They say that it was Mr. Stalin who told us, but it is not. Yes, it is.
I have no idea. I have no idea. Let me give you an example. A lot of companies are going to turn around and sort of say, well, look, I want to claim for the rent I've had to pay out. Okay. Even though my shop has been closed. Tough. you'd have to pay it out anyway. That won't be included. All that will be deducted from any claim. We will look, the way we will look at it is what is your loss of turnover, and then take away your standing expenses and everything else, and then the difference.
And also, I have a question related to the CIOC claim. You told me that there was a case in medieval times, so I don't know. Then it was related to CIOC of the vessel. And you told me that it was a big impact on the insurance industry. I didn't understand this case. Could you please elaborate a little bit? Because maybe you will provide us with more details, because I'm interested in the shipping industry as well.
Back on
actually, we have a captain here. He's name of Alexander. He's sitting and smiling. Yes. He was deeply involved in these maritime issues, and he actually dealt with some English insurance agencies.
Right. Let me bring up the actual quote on this. Was it 1764? Just a moment. I have my notes here. The Mills frigate was a vessel insured by Lloyd's, and it went on a voyage and it sank. But the vessel was in a weak, leaky and distressed condition. And what happened was the court case, there was a claim intimated, and the court case concluded with the agreement that a ship must be seaworthy before leaving shore, and that a policy could not even be paid on a ship which suffered from a latent defect unknown to both parties to the contract.
This is exactly what is written in Hague-Visby rules. I mean, they say that the vessel should be seaworthy, and the owner and is not the owner. The owner cannot rely on limitation liability clause.
No,
if the vessel was not seaworthy.
It's the both parties that you have to make. No, in an auction, buyer beware applies. You go to an auction, it is up to you to determine what you're bidding for is what it says it is. It's not up to the auctioneer or the seller to determine. I'll give you a lovely example of that, of the buyer beware bit. There was an auction for a Banksy painting. Now, Banksy doesn't do paintings. And he did this painting, he made this painting, but he never wanted it sold. And it was taken to auction, and some Middle East gentleman bid millions for it. And under auction law, once the gavel hits the ground, that is it, contract made. Well, the minute that happened, the next thing you saw was this picture was being shredded. And built into the frame of the picture, Banksy had put a shredder because he never wanted it to be sold. And that nobody knows, was he actually in the place at the time? Quite possibly. And did he activate it remotely? We don't know. But when he hit, the gavel hit the desk, it suddenly started dropping down through the shredder and coming out of shreds. For some unknown reason, it jammed halfway through, so you had half of the real picture and half of the shredded picture. There was a huge uproar then, because the Saudi gentleman refused to pay, and the auction house said, no, deal done. But you should have inspected this, and you should have seen that there was a shredder there. It's your fault. No, buyer beware. It's your job to look at something before you bid for it, and they had to pay up.
Okay, so how it is connected with this insurance claim? I mean,
well, what I'm saying is that it's your job to ensure that a vessel is seaworthy. You can't just assume it's seaworthy.
How can I do this if I'm not the ship
Specialist.
captain? Yes, I can just come to the harbor. I see the ship. Well, it's ship. It's swimming. It's working.
Floating. It's floating.
Oh yeah, it's floating. Yeah, it's floating. And so, do I need to invite a specialist every time I come there, or ask for the documents, which just help me to analyze the?
Well, you have to remember this was way back in 1760s. Ships were made out of wood in those days.
No, I understand this, but I think that the same prerequisite, I agree with Alexander Vladimirovich, I'm sorry, that it is the same stipulation we have in the international conventions, which say that ship should be seeable. How can I check that it is seaworthy?
Seaworthy.
Yeah, seaworthy.
If my memory is correct, and Alexander, I believe you're a relevant captain. I think each vessel has a certificate of seaworthiness, doesn't it? Which is what the Lloyd's.
Alexander, this is a question for you, Alexander Kovalyov. Is it necessary for the vessel to have a certificate of seaworthy or something like that?
Alexander,
I think
your microphone is off.
I think your microphone is off. Well, your microphone is off. We don't hear you.
Oh,
Yes.
It's okay. Yeah,
it's okay.
And yeah, at first, and John, thank you very much and for your topic. It's very informative for us. Yeah, I'm Alexander Kovalyov. I'm from Vladivostok. I'm doing shipping as a manager, and before I have a shipping practice many years ago, and I worked in shipping company. I'm still working in shipping company, and as operator in the charter and to make charters. Actually, it's not simple question. Yeah.
Yeah.
Yeah. And anyway, if you would like to be insured, your ship or my ship, yeah, is a you have a very lovely sample regarding paintings. Yeah. I suppose, and if we start to do something, we should know. We are experienced professional. We cannot doing and shipping or other deal if we doesn't know exactly what we can do. And if we don't know something as an owner, as a ship owner, we should be asked to be involved in the professionals and to hire these people and to pay charge and as experts like you, yeah, because and like surveyor or something like this, yeah.
I have never dealt with marine hull. I mean, that's a very specialized field. I've dealt with marine cargo, but not with marine hull. But I mean, basically what they're saying is, look, how can we insure a ship that's leaky because we know it's going to sink? That's basically what they're saying. And it's up to you to ensure that it's seaworthy before it goes to sea. I suppose you'd say, well, I'm only the owner, but I never see it. And the insurance company can say, well, we don't see it either. But isn't it a bit like saying ignorance of the law is no excuse? You don't see all the laws, you don't know them. Oh, except in Northern Ireland, by the way, it doesn't seem to apply here. That's the only way I could look at it, because as I say, marine hull is not, it's a very, very special.
Yeah. Basically, the ship is like some plant or like enterprises, the same. This is a very high technology plant. and the same procedure, and not much differences. Yeah, but then we should find the people who specialize of this matter. Yeah, if it is like doctor, if we have problem with stomach, we cannot ask an oculist or something like this. Yeah, some another specialty people. Yeah, but then your information regarding COVID-19 is very interesting. Yeah, because I never met such kind of information before. Thank you very much. Yes, it's very, very, very interesting. Yeah, because I think in especially for in law society, it is very interesting information, and because we have the same situation in Russia, like we have in UK.
We have the same situation like in the UK, but we have nothing similar like they do have in the UK. So, for example, we do not have concept of business interruption at all. No one paid anything to our companies which are going to be bankrupt or already have become or went bankrupt. So this is completely different situation. I'm surprised that your company, your insurance company, will pay compensation for your companies. This is what does it? It means that you are living, John, in a let's say true business society. I mean, it is a fair society. For example, our insurance company, I don't know what do they do actually. You know, because every time when you want to get help from them. You do not expect anything from them. The only industry where they work is car insurance, so they can pay you for some car accidents. This is the only case I've heard. Insurance is not developed in Russia at all, so basically you are lucky.
I'm just trying to find something here that was actually, if I can find it. Yeah. This was on Twitter. Bar owner has to find COVID case within a mile to claim on his insurance. So obviously an insurance company is trying to wangle out of a claim. This is to do with the cause. And I don't think he'll have a problem doing it. So will insurance companies pay out? No, they will use every excuse you can possibly think of not to pay out. And that was a lawyer actually who put it on. We converse every now and again. The lawyer's particular answer was, I don't really understand this, given the overwhelming evidence that this guy didn't invent COVID to rip off his insurance company. They're taking, what they've done is they've taken that court the decision, and they're going to apply it to the letter, let alone the word. And I think he first of all, he needs to see what the limit of jurisdiction is, and then fight the insurance company on that. But I'm not getting involved in it. Although, hang on, Beer Riff Brewing Company. Oh, maybe I will get involved. Maybe get some free beer out of it.
Yeah, it's very interesting. Yeah, it's a very good case. Yeah, to research this. Yes, why not? Yeah.
Just on this, just a very, very, very side issue. What do you call a herd of lawyers?
Herd of lawyers? What do you...
Gathering of lawyers. Yeah. What do you call them?
Just lawyers. I've heard. Just a second.
You mean in Russian or in English?
Russian.
In Russian, stada.
Sorry?
In Russian, herd is stada.
Yeah, but if you have 20 lawyers, well, we have them here in a room, what do you call them?
Just together.
Just assembly of lawyers. See? How do you call?
Somebody put up a headache.
Yes, but you know, all of our participants they keep in silence. You know, they don't want to show up. Okay, John, thank you very much for your
You're welcome.
perfect presentation. You know, I'm happy that you gave us this speech today, and I very much hope that you will participate in other our events. For example, I would like to see you as my guest speaker. Maybe Zhenya also will ask you to come, and other my colleagues also. So we are very happy that you shared with us with your thoughts and ideas, and thank you very much for your time and consideration, and we'll keep in touch.
If anybody would like a copy of that judgment, I'll just put the
Okay. Yeah. Thank you very much, John. Yeah, for
you're welcome, Alexander.
Yeah, very, very nice information. I'm very happy for inviting me to join you. Yeah, thanks very much. Yeah, have a nice day.
And you, take care.
Thank you.
Take care, John. Bye bye.
Bye bye.
Bye bye.